Case number 116174, State of Kansas v. Dustin D. Walker.
May it please the court, Peter Meharry for Dustin Walker. If I could have 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. I wasn't going to give a recitation of the underlying facts of the case because this is the other half of the previous case as far as the underlying events. I would like to point out a few of the procedural aspects that occurred during this case. My client was charged with felony murder and aggravated burglary, rising from the same incident involving Mr. Robinson. The first trial ended with a hung jury on the felony murder charge, but the jury did convict of aggravated burglary. The state tried him a second time, and again the jury hung on the felony murder charge. And it was the third trial, again just on the felony murder charge, which resulted in a conviction of felony murder. My client was subsequently sentenced to 20 to life, followed by 130 months for the aggravated burglary charge. Our first two issues are somewhat interrelated, so I would like to start with those, and they deal with some of the events at the end of the third trial. After the case was submitted to the jury and the jury went back for deliberations, apparently one of the notepads from the second trial was still in the jury room, and one juror noticed it. The juror stated he opened it, saw my client's name on it, and I think the other thing he said he saw was basically a list of witnesses. He showed it to another juror.
He did say that?
I believe he did, Your Honor.
I thought he said he saw the name and closed it.
The judge said something.
The judge indicates there were witnesses' names. But
I apologize, Your Honor. The district court stated I saw, the district court stated the juror said, I saw it said Dustin Walker at the top and I thought I should shut this. And that's from volume 38, page 3. I believe you are correct that it was the judge that said she saw the witness list. The jurors gave it to the bailiff, who then gave it to the judge, who then questioned the jurors about this. Our first issue deals with improper ex parte communications, and the jurors' conversation with the district court at that point was just between the judge and the jurors, and we believe that that is a fairly obvious violation of my client's confrontation rights. Later on, after the verdict was rendered, the district court called the two jurors back into chamber. My client's attorney was present, as was the state's attorney, and they questioned, or at least got more information out of the jurors at that point, which they basically said kind of the same thing that the district court had earlier relayed to the parties. We believe the record doesn't show my client was there, and we believe, again, that's a fairly obvious confrontation clause problem. It's a critical stage, and my client has the right to be there. And the state can certainly correct me if I'm wrong, whether or not they believe that there was no constitutional violation. I think the issue here is whether or not this was harmless. When we're talking about ex parte communications, this court has laid down kind of various factors we're supposed to look at. Strength of the case, whether or not there was objection, whether or not it involved a substantive matter, and whether or not there was any mitigation. When you look at those factors, I think they weigh against finding this being harmless error. As I said before, this was the third trial. The first two resulted in a hung jury on the felony murder charge. So we don't think you can say that there was overwhelming evidence in this case. If there was, you would think the first jury would have convicted. But they didn't. Neither did the second jury. So when
you
you
would say that's a factor for us to consider, that it's not necessarily controlling of the way.
It's one of the factors, Your Honor, and like I said, this court has laid out several factors to consider.
But I mean, in terms of the hung jury, how important is the fact of there being a hung jury to our consideration? I mean, is it almost like a given then that it's a weak case, or is it just a factor for us to consider in assessing the strength of the evidence?
I think it's probably an overriding factor that you should consider when you think about the strength of the case.
And do you have any authority from our court or any other court that suggests that?
I don't have any authority that has said a prior hung jury is the overriding factor, but I think when you look at the strength of the case, it's hard not to look at those two prior juries and say, if it's as strong as the state says, why didn't they convict? They hung on both times. It took them 3 tries. So I think when you look at strength of the case, that should be this court's overriding factor when it considers this.
And by that, do you mean it's dispositive by itself?
I think it shows that if you consider those prior hung juries, the strength of the case leans, that it's not a strong case, so when you factor in the strength of the case, it leans towards finding this was not harmless.
So if this had occurred in the first case, let's say there was a conviction in the first case, and this would have occurred, that would indicate that it was a strong case?
I don't think it would necessarily indicate it was a strong case, but I think my argument would be a lot less. Certainly you still have to look at the evidence presented, but
Well, do we know it's the same evidence? I mean, that's the problem with this when you start looking at, we don't know any, their juries don't result in a verdict always, and we don't know the reasons why. It could be one person, it could be lots of different factors, and in each one they're tried a little bit differently, aren't they?
Certainly they aren't exact carbon copies. I think in these three trials, predominantly it was the same evidence. We don't know what the jury is talking about back in the deliberations room. But what we do know is that they had questions such that they could not convict. They were not convinced beyond reasonable doubt to convict my client of felony murder in the first 2 trials. Whether or not that was 1 juror, 12 jurors, not 12 jurors, but multiple jurors, we don't know necessarily. But I think I can stand here and say that we can say that they had enough questions that they could not convict.
Mr.
Can you-
Maneri?
Go ahead.
I have a quick burden question on both of your claims. The one relating to your client's absence from these conversations with the jurors, and then the one having to do with judicial misconduct. Is the burden on harmlessness yours or your opponent's on those errors?
On the first one, I would argue it's with a constitutional violation, the burden is on the state to show it's harmless. The second one, the case law says that it is my burden to show misconduct, the judicial misconduct,
That prejudiced your
prejudice my
client.
substantial rights.
Why should that be your burden rather than the state's? Why is that different from all the other kinds of errors we say if the state's a beneficiary, it's the state's problem to show harmlessness?
I don't know. That is what the case law is. I would think it would be the same burden.
Do you
Both
think they're
cases,
just old cases that haven't accounted for our more recent jurisprudence trying to clarify where some of these burdens lie?
I'd have to go back and look at the date of the cases I cited, Your Honor. I can't recall those off the top of my head.
Okay.
It,
That's okay then.
It
I
did
just
strike me as a little odd.
Struck
because
me a little odd too. That's why I'm asking.
it seems I'm arguing a constitutional violation in issue 1 and issue 2, and it seems like the same standard should probably apply.
I understand that if it's a judicial error that the state did not promote or in any way enable, that it seems a bit unfair to place a burden on them as well. But it just does deviate from our usual, and I thought maybe you'd have some enlightening.
I don't know that I have
Precedent on
anything
that.
enlightening,
Okay.
but I would say that they still seem to be the one that benefits from this because they did get the conviction. There wasn't a mistrial, did not call because of this. So in a sense, they're wanting this court to uphold the conviction even with these constitutional problems. And they should, I would think, have to show that these constitutional problems did not play a role in the verdict.
Thank you.
If I could, I'd like to just touch briefly on the 4th issue, and that deals actually with the first trial, which resulted in a conviction of aggravated burglary. After the jury began its deliberations, it asked a question, and that question was, and this comes from volume 19, page 994, In case the jury decides that the footprint is Archie's footprint, can we hold it against Dustin? The district court responded by simply telling the jury to go back to the instructions. And it's our position that that response is, in a sense, a meaningless response and not sufficient. Defense counsel objected, actually wanted the district court to say flat out no. But regardless, we think the response given just referring the jury back to the instructions is inadequate and required something else. The jury...
Did the defendant offer something else?
No, the defendant at trial did not. I believe the defendant just wanted a flat out no, that no, you can't hold Mr. Walker responsible for Robinson's acts.
And
Something along that
And
line.
would you agree that that would have been a correct response?
I don't know exactly. I guess I have a little different view of it than trial counsel. I think we're both in agreement that what was done was wrong. It seems to me that the question is clearly asking about accomplice liability, whether or not we can hold my client responsible for another person, Mr. Robinson's act. The jury was never instructed on the law on accomplice liability. So they didn't, when the judge refers them back to the instruction, there's nothing there for them to look at to make that determination. They don't have the law to apply to the facts as they find them. And that's what I think is the problem. They just don't have anything in the instructions that would answer the question. So they ask the question, and the court just refers them back to the instructions. The district court...
How do we consider situations where nobody offers a legitimate answer to the question? I understand that it would be helpful to have a meaningful response, but is it really up to the judge to develop that on his or her own without the parties presenting something that the court knows you can move forward without creating yet another error or a potential error, a first error maybe, whatever?
I guess a couple things. Number one, I think it is the judge's responsibility. It's in the statute. Certainly if the jury has a question, the judge has a responsibility to make sure the jury knows what they're doing. So I think at the end of the day, it's still the judge's responsibility. Now, whether or not the party should supply something, in this case, defense counsel did object to the response. And I don't think there's any indication that the district court would have been more open to some other suggestion than the suggestion that was made. Defense counsel said, I want you to say no. District court said, no, I'm just going to refer him back to the instructions. Had defense counsel said, I think we should instruct on accomplice liability, I don't know that there's any indication the district court would have said, okay, we'll do that. So I think the district court here has the ultimate responsibility to make sure the jury is properly instructed and questions they have are properly answered. And the district court just did not do that in this case. So again, the jury had been read the instructions. The jury had the instructions. And even after that, they had this question. So I think the district court's decision to just refer them back to the instruction is meaningless and not sufficient response to the question.
Do we have any more questions? We've taken a lot of your time with questions. Do you need 30 seconds to kind of wrap up, or are you going to wait till rebuttal?
I'll use it on rebuttal, Your Honor.
Very well, thank you.
Good morning, and may it please the court. Assistant District Attorney Kate Duncan Butler on behalf of the state. And this morning we would ask that you affirm Mr. Walker's convictions in this case. To start where Mr. Walker's counsel did in terms of the communication with the jurors, outside of the presence of Mr. Walker and of counsel, our brief does recognize that that is a violation of his right to be present at critical stages, but we disagree with Mr. Walker's outcome of the harmless error test. I think in this case, the state's case was very strong, which is the first fact to be considered. Yes, there were hung juries, and while I think that is something this court can consider, I do not think it is dispositive or even necessarily as important as Mr. Walker's counsel would like this court to make it. I think it was Justice Rosen who pointed out that we can't be inside of jurors' minds. There was definitely testimony presented at the first trial that was not presented at subsequent trials. That was the only trial in which Mr. Walker testified. And so that obviously could have influenced that jury, as well as the order of presentation, the way questions are asked, the way witnesses answer them. There are so many variables that could affect one juror, or we don't even know how many jurors, to end up with a jury not being able to render a verdict. And so while I think this court can absolutely say, well, the evidence didn't convince two juries we should look at that, I don't think it is
Let's look
overriding.
at the harmfulness from a different aspect. The judge is back talking to the jurors about these notes that they discovered left behind in the jury room. No one else is there, and so neither defendant or defense counsel gets to participate in eliciting just the impact. I mean, isn't that why you have to be present, so you can see what's going on, you could participate in your own defense? And so I see maybe the judge didn't ask the right questions from the jurors.
Well, I think, and in terms of why any communication between the judge and jurors is a critical stage, I think that's exactly why, the defendant's ability to participate in these conversations. But one of the factors when we're looking at harmlessness is objections from the defendant. I guess I'm about to name two factors, and the content and the manner of communication. All of this, I did not try this case, but I've spoken to trial counsel. All of this happened very quickly and very fluidly. The conversation and the shredding of the notes sort of happened behind the scenes, and then they were left.
And could you just factually here, and I get back to Justice Johnson's question, but did the judge speak with both jurors who opened the notebook one at a time? How did that happen?
I do not have all those details. I think the record made in chambers with everyone present, so not the post-verdict conversation,
I understand,
but first.
right.
I think that is the best recollection of anyone has of what happened, and it's not clear.
Because one version in the record is she spoke to the one that handed. Did she speak to both of them that opened it, or just one?
That is
Ex parte?
unclear from
Okay,
the record.
The first time, she may have only spoken to one.
Correct. Your
That's
Honor.
okay, and you can get back to the answer to the question. I just wanted to get.
And the only thing we have to go on about what happened in that first meeting is only from the judge, or do we also have statements from the jurors in the second meeting about what occurred in the first meeting? In other words, not just what occurred when they found it, but what occurred in the first meeting with the judge.
I do not believe, and I don't have the record with me, and I apologize, I do not believe that at the post-verdict conversation, the jurors gave a recitation of what had happened in the first conversation. I think it's important to note they say at that time the same thing that the judge said they said.
About the substance.
Yes.
It's just, we have very little information about exactly what went on in that first conversation.
And that is absolutely true.
And that's what makes it hard to do harmlessness. Because this isn't a situation where we have a lot of information about what happened in spite of the absence of the defendant. Here, we're really impaired on that.
But the defense counsel were present at that second meeting, correct?
Yes.
And had the opportunity to ask questions of the juror?
Correct. And at the first meeting, and this goes to the objection of the defendant factor that I was going to speak to Justice Johnson about. At the first meeting, when the judge came back and said, here's what happened, here's what I said, here's everything.
And how long after the event did that get reported to the parties?
I don't know. I believe it was in fairly short order. I spoke to trial counsel shortly before today, and she didn't, it's been a while, she didn't exactly remember. She just remembered they tried to get it on the record as soon as everyone knew what had happened.
Yeah, I can understand that everybody wanted it on the record as soon as they knew, but we have a hole in our information about the amount of time that had passed between the judges telling them and the,
Yes.
and the event itself. Yeah.
But
Okay, thank you.
I'm sorry.
I was going to say, what do we make of the fact that twice counsel were asked if they wanted to question the jurors, and twice counsel said no?
And that was the point I was actually just about to make, Chief Justice Nuss, that they, at the first conversation, I keep calling them conversations, the first chambers meeting, defense counsel was asked, with Mr. Walker present, do you want to question the jurors? And defense counsel said, based on what I've heard now, no. There is no indication that Mr. Walker protested, objected, told counsel, hey, I wanted you to question those jurors. And then at the post-verdict chambers meeting, which again, there is no, that in that situation, there is no indication Mr. Walker was present, so we must presume he was not. Defense counsel again says, I don't need to ask any questions, which I think goes to whether there was an objection from Mr. Walker. And I think it's also important to note, and I realized this when I was doing some review, that the shredding, although obviously not in the original form, was retained by the district court, and there's no indication that Mr. Walker or his counsel ever asked to go in the bag and see and try to piece this together, which I think is another, just in terms of going to the objection from
Was that
defendant.
noted anywhere, that the shredding was?
Yes, I actually have the record site. It's volume 35, page 1186. The district court judge says something to the effect of, my assistant has retained the shred bag. It may very well still be at the Judicial and Law Enforcement Center in Lawrence. That I don't know. But regardless, it was not requested at that time as far as I can see. And I also think, to circle all the way back to Justice Johnson's question, this was a very, in terms of content and manner of communication, it was a very brief conversation from everything we can tell. The judge's recollection of what the jurors say are consistent with what the jurors say they saw. So there's no reason to believe that from that there was any misinterpretation of that conversation. And the conversation was not about the substantive issue. It was, what did you see? You essentially saw nothing, and conversation over. It was not about, well, tell me about the contents and how do you feel about it. It was none of that. It was not, okay, it just was a very brief factual conversation of, all you saw was Dustin Walker's name, which again is what the jurors say later. And I think that's important when we're looking at the effect of this.
On that, the point of what they might have seen, it seems strange to me to shred a notepad and then say, I kept the shred bag. Can we make anything of that? Is that sort of an implicit admission? Oh, I shouldn't have shredded that. We better keep the shred bag.
I actually think the judge in this case makes an explicit admission that she probably should not have done what she did. I don't think there was any, and this sort of goes into the judicial misconduct issue, I don't think there was any bad faith on the part of the judge. I think the judge had the thought of, this should have been
So it was
shredded.
mitigation. It was like, I might have made a mistake, but I can mitigate it by keeping it and making it available.
Yes, Your Honor.
Okay.
I think everything that happens is a mitigation of an oops that occurred, for lack of a better word, that everyone realizes the situation's not ideal, but I don't necessarily think that because it's not the ideal situation, it rises to the level of reversible error when we're looking at the brevity and the lack of objection.
Can I move you to the question I asked your opposing counsel about who should bear the burden of demonstrating harmlessness on the judicial misconduct? Is there a reason that should be on the defendant as opposed to on the state?
Well, I think it's important that when we're looking at judicial misconduct, it's not necessarily, the rule is not, it is the defendant's burden, it's the party alleging misconduct. And so if the state were to reserve a question on judicial misconduct and allege misconduct.
But why should that be? I mean, I'm just really puzzled by that, because I mean, I understand what you're saying, but in a criminal, let's just say, okay, but in a criminal context, why should it ever be the defendant? Judicial misconduct here, I think everybody would agree, it looks like it's a pretty minor event anyway. it wasn't some pervasive bias demonstrated throughout a trial, that sort of situation. I just don't understand, if you had that more serious situation, why would the burden would ever be on a criminal defendant?
Well, I think
It's such a vital part of a fair trial, to have a fair judge.
And I would agree that it is having a fair judge in a criminal trial is very, very important. But I think when we're looking specifically at judicial misconduct, the idea between or about the state bearing the burden of error in a criminal trial is often the state is the beneficiary of that error.
Right.
In judicial misconduct, I don't necessarily think there is a beneficiary. And especially, I know this is not, as we said, a very serious, if it is misconduct at all, a very serious instance of it, but the state certainly did not encourage or create this situation. The state
Yeah, I understand.
is also put in a problematic position by it, because now we're trying to prove that there was no error when there are so many unknowns.
And it was done before the state even knew about it.
Correct, Your Honor.
I mean, this is beyond not facilitating it. This is totally unaware.
Correct, Your Honor. And so I think that is why that the party alleging misconduct is shouldered with the burden.
Are there any other areas of criminal law in which, if the state was benefiting from the error, it has the burden? It does not have the burden to prove harmlessness?
Not that I can think of. That does not mean it does not exist. None that I can think of, but I also think, I would argue the state isn't benefiting from this in this case. I think both parties are equally disadvantaged by what happened in this particular situation. And that's not to say in all situations of alleged judicial misconduct that is true. But I think it's also important that the whole idea behind judicial misconduct is that the court, looking at it, must consider carefully the facts and circumstances. And so there may be situations where this court could say the state definitely benefited from this alleged misconduct, so perhaps they have a higher burden. I just think that's not the case law at this time. And in our brief, we argue this is not judicial misconduct. Judicial misconduct is often when the judge is abdicating their role as the impartial, fair governor of the trial. There's no indication this judge acted with bias or was intemperate.
Well, how did she act? I mean, really, evidence was destroyed.
The evidence still exists. I think it wasn't.
Well, there was an attempt. I mean, I understand maybe it was impulsive, not thought through, but evidence was destroyed in the judge's hands before anyone had an opportunity to look at it, other than the two jurors.
I think the judge had a very human knee-jerk reaction of, this should have been done before, we're going to do it now. Even she admits, I thought after I did it, the counsel would want to look at this. Basically says, like, I acted rashly, but I think misconduct, it's sort of, as I was thinking about it the other day, I was likening it to prosecutorial error versus prosecutorial misconduct. Misconduct, I think, implies, if not ill will, at least a level of sort of abdicating the judge's duty, and I don't know if we can go that far in this case.
At a minimum, a judge has a duty to preserve the record, right?
That is correct, Your Honor.
Yeah, so that's, like we said, this is pretty low level, a problem for, to be observed in a judge's conduct, but it's problematic from that angle, at least, the shredding part. Anyway, thank you.
Justice Luker, did you have
That was
have a question?
basically the same thing I was going to say.
Oh,
So.
Right. Well, I see I'm nearly out of time. I would just rest on my brief and ask this court to affirm Mr. Walker's convictions unless this court has any other questions at this time.
Any more questions? Thank you, counsel.
Thank you.
I'm glad I reserved rebuttal because I can't believe I went through my whole initial presentation without saying shredding. We did contact Douglas County Clerk. We did ask for the shredded notes. They had no idea what we were talking about. So we tried to get it. I don't know exactly what I would have done with it, but We did try to get it from Douglas County, and they did not have it. And I do think, I understand is this, likening it to prosecutorial misconduct or prosecutorial error. Misconduct does imply some sort of kind of unethical undertones. And I don't think that was the case here, but the district court clearly made a mistake when it shredded those notes before showing them to counsel. And I think that is important in and of itself, but also because defense counsel was kind of hamstrung after that.
As was the state.
As was the
It
state.
just, it really prevents our ability to go behind what happened outside the defendant's and defense counsel's presence. It just eliminates the ability to check. That's the problem, and the state happens to have gotten a conviction, so they want us to think it wasn't that big of a problem, and you happen to have
I would probably disagree.
be facing imprisonment, your client,
yes.
and so you think it's might have been a bigger deal. But
Yeah,
the
and
bottom line is we just don't know.
And we don't know, and
We don't have a
certainly,
way of checking.
there's a reason why both sides get to look at evidence. There's a reason why we have defense attorneys and prosecutors and a judge. We don't just have a trial and say, judge, make sure it's fair.
Given that this happened, is there anything else that the district court judge should have done in your mind? You're not arguing. I did try to cure whatever happened in a pretty thorough, comprehensive way.
I think as far as after shredding, I'm not sure what else the district court could have done. They did bring the jurors back. They did question the jurors. But I think by that point, the harm's already done. My client and his attorney are kind of behind the 8 ball because they haven't seen those notes.
But is it factually true, the allegation that the shredding prevented a meaningful, I'm quoting your brief, prevented a meaningful opportunity to review the notes? Is that factually true? If in fact the judge, I know they're shredded, but said, here they are. And your client's counsel at the time passes on that opportunity.
I think it still does. Because I think when you shred something, that is not, I don't think, a reasonable avenue to take. The idea that you can go through, I've got a shredder at home, I throw paper through there. There's just no way I'm piecing that together, I don't believe. And I don't think defense counsel, that's a realistic way for defense counsel to say, no way, judge, I want to go tape all this back together. I don't think you can do that. So I think the shredding did prevent my client from having any reasonable opportunity to challenge this and question those jurors.
You would say it's akin to, I burned them up and here's the ashes kind of a thing.
It's pretty close.
Okay.
The jurors in front of counsel did say, this is what we told the judge. We opened the notepad, closed it upon reading Walker's name, we gave it to the bailiff.
That is what they, I'm sorry.
No, go ahead.
That is what they said. But I still think the ability of defense counsel to delve into that, to question those jurors, is hamstrung because the defense counsel has not seen those notes. He's in no position to question them. He can't say, well, the front page says guilty. I don't know if it said that. Nobody, I suppose the judge might, but we just don't know.
Well, counsel could have pursued that. I understand would not have the document in front of him or her, but could say, now, let's talk about some other things here. Was there anything else on here? What did you read? Because witnesses get cross-examined all the time without documents. And I understand that there is a problem without having the document there to cross-examine. But for defense counsel to say, I don't need to talk to the jurors twice, I'm just kind of curious why it was left like that.
I don't know exactly what was going through defense counsel's mind, but from my vantage point, there was very little he could do at that point because he did not have those notes. He just did not have a basis to question what the jurors were saying.
Did he question the judge?
I
Or
believe,
whoever counsel was, man or woman, I don't know.
I don't believe he questioned the judge. I think the judge just kind of recited what she said happened when she first talked to the jurors. And I don't think anything went beyond that, Your Honor. I don't know if the attorney tried. I don't think he tried to, as far as I recall. That's, as an attorney, that seems a little odd to me to start questioning the trial judge, but I don't believe there was any attempt to do so. Again, I would go back to, I think the harm is done because he does not have those notes in front of him.
Was there a motion for a mistrial?
I don't believe he raised it in motion for a new trial or mistrial.
All right. Any other questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. This time